Hello, my name is Michael Lupman, one of the partners responsible for ThinkHouse at Rag & Co. In this session we'll be talking to Tom Price, a director in our commercial litigation team specialising in international disputes. He'll be talking us through jurisdiction clauses and how important they are. Tom, what is a jurisdiction clause and why does having one in a contract matter?
The jurisdiction clause is the clause that appears towards the end of the contract and sometimes does not get as much attention as it might do at the negotiating stage. It's the clause that sets out the dispute resolution mechanism for your disputes should you have them further up the track. It sets out the courts that are going to hear that dispute, the court of a particular country, or if you've decided on an arbitrator, it sets out the arbitration provisions for resolving that dispute. It certainly matters that you have the clause in there because if you don't, you're going to be left with uncertainty and expense.
Should the clause stipulate a particular jurisdiction or court? What are the options?
Well, it certainly should state a court. The first choice is it going to be arbitration or is it going to be a state court? And there are a series of factors that you need to take into account there. To do mainly around enforceability. Arbitration can be a little bit more widely enforced and can be confidential, but you may want a court to hear your dispute instead. And then you have to decide which courts it is. Is it going to be the courts of England, assuming that you're the English company, or the courts of another country, maybe the court of your counterparty, or indeed possibly the court of a neutral country. And if it is going to be a court clause, is it exclusive or non-exclusive? An exclusive clause is one where you choose a court system and that's the only court that can hear the dispute, or non-exclusive, you choose a court system but the parties can go to another court.
How enforceable are jurisdiction clauses?
Well, as far as the English court is concerned, and indeed the courts around the EU, they are enforceable. The courts will give effect to what the parties have chosen. So if it is an exclusive jurisdiction clause, then that's where you and your counterparty must go. If you decide you want to go to another court, particularly in the EU, you will find that that other court will turn your dispute down. So certainly with exclusive jurisdiction clauses in the EU, you're pretty safe. With non-exclusive clauses, by definition, they're meant to be more flexible. You can go elsewhere. If you're talking about outside the EU, it is even less certain, and in some countries, certainly in Russia, other CIS countries and China, for example, those courts are less inclined to enforce even a jurisdiction clause in favour of only the English court. So you need to take care when you're dealing with those jurisdictions.
Are there alternatives to jurisdiction clauses? And if so, what are they?
Well, I touched on this earlier. The main alternative to a jurisdiction clause is an arbitration clause. It's designed to do exactly the same thing, resolve your dispute. It's just that the process is different. So an arbitration is a private process, a contractual process, as opposed to a court, which is clearly a state court deciding a matter in public. And the real choice here is, as I alluded to earlier, is between arbitration, which is confidential, and private, and in many instances more easily enforceable because of the New York Convention, which applies to over 150 countries, so you can enforce your award around the world in some fairly far-flung jurisdictions, as opposed to court proceedings where you end up with a court judgment and you may struggle to enforce that judgment in certain countries. So it's a bit of a toss-up between the two, and there's no one right answer. It's a question of looking at the factors to see what suit you when you're negotiating the contract.
Is there such a thing as the right jurisdiction clause?
Well, there is no such thing as the right jurisdiction clause. It is a question of the factors that you need to be looking at when you're negotiating the contract. So I think that breaks down into two main factors. It's where are you going to be more comfortable in terms of resolving your disputes. I'll come back to exactly what that means in a second. And secondly, how easy is it to enforce the award or judgment that you get at the end? So there's often a tension between those two factors. Again, if you're an English company, it is likely that you want to be in the English court or possibly with an English arbitration because you know the procedure and you understand the system. But if you're contracting with somebody from overseas, as is often the case, and you need to enforce any judgment or award against assets abroad, then you may be in the English court, but you've now got to take your judgment and enforce it somewhere else. Wouldn't it be better just to go and have your dispute resolved in their foreign courts first off? Of course, the danger with that is you're unfamiliar with those courts or arbitration processes. So it is a real trade-off, and it's a question of how you feel about it and the sort of risks you want to take.
What happens if a contract doesn't include a jurisdiction clause? Is it a problem?
It is a problem, and it's increasingly and surprisingly frequent. It never ceases to amaze me how many times you see a contract without a jurisdiction clause. It is a problem because, as I mentioned earlier, without a jurisdiction clause, you lack certainty as to where your dispute is going to be resolved. And since jurisdiction is the first point that you have to resolve, it's the first major headache that you have, and often one you can do without. And what happens without one is that you have to rely on the rules that are imposed, and they are complex and uncertain and allow you and indeed the other side to play games and to spend money. So it is far better to have a clause which is agreed on and that you can rely on.
Assuming the contract includes a jurisdiction clause, can either side get out of it?
Well, it comes back to whether it's exclusive or non-exclusive, and again whether you're in Europe or not. If you have an exclusive jurisdiction clause and you're thinking of trying to take your clause and take your dispute somewhere else within the EU, you're not going to get very far because any other court is going to turn your dispute down. You can play something of a game if you want to do that, because if you take your dispute to another court, the English court must wait until that court has at least opined on the subject. That may take several months, and so you can buy yourself a little bit of time in doing that. So if you can take your dispute to another court, but ultimately you will not succeed. With a non-exclusive jurisdiction clause, of course, you have the freedom to go to where you want to go to. It is easier to try and wriggle out of a jurisdiction clause that you don't like if you're talking outside the EU, where the courts of other countries may be far more willing to take jurisdiction in breach of a clause in favour of somewhere else.
Tell me the issues around choosing the right governing law.
Well, governing law is an entirely different matter from jurisdiction. Governing law is to do with the substantive law of the dispute, whereas jurisdiction is to do with how you resolve your disputes. In practice, one finds that people tend to put a governing law clause in a contract more willingly and freely than a jurisdiction clause. And probably the reason for that is because the parties are thinking about what the contract means, and unless they've decided what law governs the contract, it's hard for them to know what they're talking about. So one tends to see a governing law clause more frequently. And to the extent that there is any debate about that, that usually comes because one party is simply from one jurisdiction, one from the other, and you tend to want your the governing law that you are familiar with. And certainly that is the main driver behind choosing a governing law clause. The important point is that it does not need to match the jurisdiction clause, so if you have an argument about where you should resolve your dispute, you can still have, say, English law, and then the contract can be governed by that law, even if it's resolved in a different jurisdiction.
For in-house lawyers dealing with these issues, what three things should they do?
Well, overall, for jurisdiction and governing law, the three main things that I think an in-house lawyer needs to do is this. First of all, have a jurisdiction and governing law clause. And by that I mean both of them. Don't just have one. Many times people say this contract is governed by English law and they think that covers everything. It doesn't, so you need both governing law and jurisdiction. Secondly, understand what the drivers are as to whether you should have arbitration or litigation, and if so, which courts, and understand that by reference to the procedures in play in various jurisdictions and enforcement. And then thirdly, the sort of S-level question, once you've got all of those buttoned down, is try and make your life a little bit easier by making your clause work for you. So have a process agent for accepting service of proceedings, which will obviate the need to serve proceedings abroad. Maybe put in a mediation clause in there as well to help see if the dispute can be resolved before it gets to arbitration or litigation. If you do those three things, I think you have put yourself in the best position you can be in.
Tom Price, that's good advice. Thank you very much.